Thank you very much, and it's a really great honour to welcome this audience, but more important than this audience, this gathering here this evening. This is a special event at the National Security College here at ANU. It is the launch of an important review and issues paper by the Independent National Security Legislation Monitor. It's also a particular pleasure to welcome our speaker and chief guest this evening, the Commonwealth Attorney-General, the Hon Michelle Rowland MP. I also welcome many distinguished guests from across the national security community, the legal profession, civil society. I won't name and list all of you here today, but it's great to welcome the Secretary of the Attorney-General's Department, the Commonwealth Director of Public Prosecutions, Inspector General of Intelligence and Security, Australian Government Solicitor, President of the Law Council of Australia, UN Special Rapporteur, representatives of the Victim of Terrorism Association, Chief Police Officer for ACT Policing, Chief Justice of the ACT Supreme Court, Australian Human Rights Commissioner, a former Attorney General and colleague here at ANU, and so many others. Together, your presence is a measure of the deep relevance of our conversation tonight to our nation, to its security, its interests and its values. Let me also at this point acknowledge and celebrate the first Australians on whose traditional lands we meet, the Ngunnawal and Ngambri people. I pay respects to their elders, past, present and emerging, and extend that to all Aboriginal and Torres Strait Islander people here. Now, we're here to consider a crucial issue in the way that our democracy approaches an enduring security challenge. That is, how should terrorism be defined by law? The review in question, and of course the issues paper, which I recommend to you all very strongly to digest and respond to, and you have copies on your seat. The review in question is an own motion initiative by the Independent National Security Legislation Monitor, Jake Blight. And I'm very appreciative that Jake and his team have entrusted the National Security College to hosting this conversation. Now, we'll hear more from the Insulum shortly, including with context for the review and the thoughtful issues paper. Jake will then join me in conversation about the paper, and we will invite your questions as well at that point, along with Law Council President Juliana Warner and Professor Ben Saul. The exercise in consultation and transparency that we're really embarking on this evening is very much in keeping with the mission of the National Security College, which is a joint initiative of the Commonwealth and this university, with a mission of keeping national capability and national engagement in pace with the changing challenges of the times. Indeed, I should note that the college has its own community consultations underway at present, which encourage Australians to tell us about how they understand national security. And so I encourage you to take a look at our own issues paper as well as part of the broader landscape of risk and resilience. And there'll be copies of that issues paper in the gallery if you join us for refreshments afterwards. But the topic at hand is defining terrorism. And we're privileged that the Attorney-General is joining us to frame our discussion with a significant address. The Hon Michelle Rowland MP was appointed as Commonwealth Attorney-General not so long ago, but May 2025, and already is very much in the midst of this term of government and the challenges and the opportunities that brings for the national interest. She has been member for Greenway since 2010 and has previously held the role of Minister for Communications. Prior to being elected to federal parliament, she was a lawyer, practiced as a lawyer in the communications industry, but I was also really struck by the fact that you served as Deputy Mayor of Blacktown City Council. So, Attorney-General, perhaps we should speak with you in our community consultations at some point. But it is an honour to have Australia's Chief Law Officer provide a Commonwealth perspective on the evolving terrorist threat, alongside the importance of checks and safeguards in a dynamic and effective national response. So please join me in welcoming the Attorney-General.
Good evening, everyone. And of course, I begin by acknowledging the traditional custodians of the land we're gathered on and pay my respect to elders past, present, and emerging, and particularly acknowledge and welcome other Aboriginal or Torres Strait Islander people attending this event. I firstly give my thanks to the Independent National Security Legislation Monitor, the INSLM, Mr. Jake Blight, for the invitation to speak here tonight to mark the launch of the review of the definition of a terrorist act in the Commonwealth Criminal Code Act. Keeping Australians safe is the foremost priority of any government. And I acknowledge that there are so many people here tonight who have played and continue to play a significant role in keeping Australians safe at home and abroad. I particularly want to note this evening that we're joined by Louisa Hope, a survivor of the Limp Cafe siege, and Alfred Cheng, whose father Curtis was tragically murdered in a terrorist attack outside the New South Wales Police headquarters in October 2015. And I also acknowledge representatives from the Victims of Terrorism Australia. Terrorism is unlike any other crime. Over the past 20 years, it has shaped our national security landscape, our laws, and our collective sense of safety. On September 11, 2001, the world was changed completely. Though that tragedy occurred thousands of kilometres away, its reverberations were felt in every nation. I remember as a young girl the Sydney Hilton Hotel bombing in 1978. That was the first significant terrorist attack on Australian soil, and it triggered a shift in our approach to national security matters. However, 9/11 marked a true turning point in how we understood the threats facing our country and how we responded to them, legally, operationally, and as a community. Our sense of distance was forever shattered when, in October the following year, hundreds of lives were lost in the Bali bombings, including 88 Australians. Ever since that time, the threat has remained real, immediate, and personal, with Australians having faced numerous acts of senseless and indiscriminate violence. Though we can quantify the number of fatalities and injuries of terrorism over more than 20 years, this cannot alone explain the impact on the psyche of the Australian people. It does not capture the trauma, the division, and the fear that each of these attacks leaves in its wake. The threat of terrorism to Australians and Australian interests has continued to evolve. As the Director General of Security noted in his 2025 National Threat Assessment, Australia's security environment is more volatile and unpredictable than ever before. While transnational networks like ISIL and Al-Qaeda remain active overseas, we have also seen unacceptable nationalist and racist violent extremists continue to rise. In response to this complex threat environment, successive governments, law enforcement agencies, intelligence bodies, and communities have worked relentlessly to strengthen our responsiveness and resilience. I particularly acknowledge the tireless dedication of these very intelligence and law enforcement officials and how they've disrupted dozens of major terrorism plots, saving countless Australian lives in the process. And I want to be clear here, I'm not talking only about Commonwealth officials. Countering terrorism is a true partnership between Commonwealth, state, and territory governments. These are some of the strongest relationships within the Federation, and I thank you all for your continued dedication to keeping our country, our people, and our institutions safe. In part, the success of our response has been enabled by a legislative framework that was responsive to the evolving threat landscape. This framework is underpinned by an intergovernmental agreement, which is another pillar of the deep interjurisdictional partnership, which has allowed the Commonwealth to legislate in a comprehensive and responsive manner. A range of counter-terrorism laws have been introduced since 2001, from prescribing terrorist organisations to criminalising preparatory acts and foreign incursions. These laws have been directed towards keeping Australians safe. They have focused on preventing, responding to, and recovering from terrorist attacks. As the methodologies, targets, and objectives of terrorism have changed, so too have these laws, ensuring our law enforcement agencies and our intelligence agencies are appropriately equipped to respond. Now, at the heart of all these laws is the definition of a terrorist act. First introduced into the Criminal Code in 2002, the definition has remained unchanged ever since. Currently, terrorism is defined as an act or a threat of an act done with the intention of advancing a political, religious, or ideological cause with the aim of coercing the government or intimidating the government or the public. Crucially, the act must cause or intend to cause serious physical harm, death, endangerment, or serious damage to property, or create a serious risk to public health or safety. Terrorism is a very specific kind of crime. It is not only about violence or destruction. It is about violence motivated by a cause and with intent to influence or intimidate, striking fear into the broader community. It is about targeting not just people or places, but our collective sense of safety and the very values and institutions that hold our society together. This is what sets terrorism apart from other forms of criminality. A fraudster seeks profit. A violent offender may act out of rage or desperation. Both are criminals and cause harm to specific victims. But a terrorist seeks to use fear as a weapon to reshape society. The harm caused is not only to particular individuals or property, but to our collective sense of safety, our trust in government, and our cohesion as a democratic and pluralistic nation. Its often indiscriminate nature leaves all members of the community thinking, that could have been me. This is what elevates terrorism to be one of the most serious threats facing our nation. Terrorism is deliberately symbolic. It aims to send a message, to undermine confidence in the rule of law, to provoke division, to incite further violence, and to drive wedges between communities. It is this broader social and psychological impact that makes terrorism so damaging. It exploits vulnerabilities and can foster fear, suspicion, and resentment, the echoes of which remain long after the attack itself. Left unchecked, it corrodes the social fabric that binds us together. In the face of this threat, governments are often required to respond in ways that may infringe on individual rights and liberties for the fundamental objective of keeping Australians safe. Australia has enacted a broad suite of counter-terrorism and national security legislation over the past 2 decades. These laws have given our agencies critical powers to prevent attacks, to disrupt plots, and to protect the Australian public. The challenge for lawmakers is to ensure that our response is firm but fair, strong but principled. In doing so, we not only defend our safety, but the very values that define us as Australians. Getting that balance right means we not only equip the institutions and agencies with the powers they need to keep us safe, but that we always have an eye to the rule of law and ensuring that the national security framework remains proportionate and necessary. Good national security policy does not ask us to choose between safety and liberty. It demands that we protect both. That is our duty, not only as lawmakers, but as citizens of a democratic nation. It is fair to say that terrorism and our response to it will often require us to consider and test the balance between liberty and security, and prompt deep reflection on what it means to be a free and safe society. The role of our oversight bodies in these circumstances cannot be understated, including that of the Independent National Security Legislation Monitor. Australia's national security architecture is stronger as a result of its oversight framework. This framework contributes to the trust the community has in our law enforcement and our intelligence agencies, and it underpins their social licence to perform their vital role. In the first instance, the Parliamentary Joint Committee on Intelligence and Security plays a critical role in scrutinising national security legislation and supports the Parliament in its consideration of these important bills. Courts also have a critical role to play in interpreting and enforcing laws. However, many activities are necessarily covert and may never be aired in a courtroom. For this reason, the Inspector General of Intelligence and Security performs a vital role in providing assurance that agencies act with legality and propriety. However, it is also important that the laws themselves are subject to review. That is why Labor established the Independent National Security Legislation Monitor in 2010. The Monitor's role is to assist ministers by considering the operation, effectiveness and implementation of Australia's counter-terrorism and national security laws, and whether those laws contain appropriate protection for individual rights. And that they remain necessary, that they remain proportionate, and that they are consistent with Australia's international obligations. The Monitor is appropriately invested with the necessary powers to conduct these reviews. And last month, I introduced into Parliament my first bill as Attorney General, the Strengthening Oversight of the National Intelligence Community Bill, which expands the Monitor's remit to ensure they are empowered to review any counter-terrorism or national security law on its own motion. I greatly appreciate Mr. Blight, Australia's first full-time Monitor, undertaking this review of the definition of a terrorist act. The complexity of the threat and the corresponding legal framework makes this review an unenviable but a critically important task. I encourage any Australian who is interested in these significant legal matters to engage with the review, to share your views and your expertise. And I sincerely look forward to receiving the Insolence report in due course. Now, while I've spoken about laws and the role of government, I wanted to finish by recognising the other critical partner in countering terrorism, the community. We know that the best way to prevent radicalisation is to ensure that all Australians, regardless of their background or their belief, feel heard, valued and protected. That is why partnerships with communities, why education programs and early intervention initiatives are an essential component of our national counter-terrorism and violent extremism strategy released earlier this year. Terrorism in all its forms, whether religiously, politically or ideologically motivated, is a rejection of democratic coexistence. It seeks to replace dialogue with violence, pluralism with fear. We must be steadfast in resisting that aim, not just through law enforcement and intelligence, but by strengthening the values that define us as a free and open society. I reaffirm the Albanese government's commitment to standing against hate. Extremism thrives where division festers. Together, we must remain vigilant, principled and united. As Attorney General, I'm committed to ensuring that our legal system continues to provide the tools that are needed to address these threats while safeguarding the rights and freedoms of all Australians. National security cannot come at the expense of our democratic values. It must reinforce them. For in defending ourselves against terrorism, we define not only our security, but the character of our nation. Thank you.